Welcome to our Federalist Society event, Fighting the Big Six Menace. We have two illustrious speakers, so thank you both for being here. I'm excited to get started. So first, we have Josh Hamlin, who is a senior editor at large at Newsweek, a research fellow with the Edmund Burke Foundation, counsel and policy advisor for the Internet Accountability Project, a syndicated columnist through Creators, and a contributing editor for Anchoring Truths, a frequent pundit and essayist on political, legal, and cultural issues. Josh is a constitutional attorney by training. He hosts The Josh Hammer Show, a Newsweek podcast, and co-hosts the Edmund Burke Foundation's NatCon Squad podcast. As an outspoken conservative, Mr. Hammer opines on conservative intellectual trend and contemporary domestic and foreign policy debates, constitutional and legal issues, and the intersection of law, politics, and culture. He has been published by many leading outlets, including the Los Angeles Times, the New York Post, Daily Mail, Newsweek, National Affairs, American Affairs, the New Criterion, and many others. He has also been published by the Harvard Journal of Law and Public Policy and the University of St. Thomas Law Review. Mr. Hammer is a college campus speaker through the Young Americans Foundation and the Intercollegiate Studies Institute, and a law school campus speaker through the Federalist Society. Prior to Newsweek and the Daily Wire, where he was an editor, he worked at Kirkland and Ellis LLP and clerked for Judge James C. Ho in the United States Court of Appeals for the Fifth Circuit. He has also served as a John Marshall Fellow with the Claremont Institute and a Fellow with the James Wilson Institute. He graduated from Duke University, where he majored in economics, and from the University of Chicago Law School. He lives in Florida, but remains an active member of the Texas Bar. And we also have Professor Jacobson, who is a clinical professor of law and the director of the Securities Law Clinic here at Cornell Law School. He's a 1981 graduate of Hamilton College and a 1984 graduate of Harvard Law School. At Harvard, he was the senior editor of the Harvard International Law Journal and director of litigation at the Harvard Prison Legal Assistance Project. Prior to joining Cornell Law faculty in 2007, he had a highly successful civil litigation and arbitration practice in Providence, Rhode Island, concentrating in investment, employment, and business disputes in the securities industry, including many high-profile cases reported in leading newspapers and magazines. Professor Jacobson has argued cases in numerous federal and state courts, including the Court of Appeals for the First, Fifth, and Sixth Circuits, as well as the Rhode Island Supreme Court. Professor Jacobson has a national reputation as a leading practitioner in securities arbitration. He was a treasurer and is a former member of the executive committee and board of directors of the Public Investors Arbitration Bar Association, a professional organization of attorneys dedicated to protecting public investors. He is frequently quoted in national media on issues related to investment fraud and investor protection, and in the past has served as one of a small number of private attorneys who trained new arbitrators for the Financial Industry Regulation Authority. He is a co-author of Securities Arbitration Desk Reference, updated annually. He is also a founder and publisher of Legal Insurrection, a popular politics and law website. He is frequently quoted in the media on political and legal topics and has authored many op-eds in major publications and appears on television and radio to discuss politics and the law. Thank you. Whenever you're ready.
All right, well, thank you all so much for having me. I haven't been to Cornell since I was a senior in high school, so it's been 16 and a half years. It's really pretty. I honestly forgot how pretty it is. Just I flew into the tiny airport here and sort of like drive to my hotel. I grew up downstate in Westchester County. I genuinely forgot how pretty this part of New York State is. So really great to be here. Delighted to be joined by Professor Jacobson, who I think I've been acquainted with online for a decade or longer. This, I think, is our long overdue first time meeting in person. So it's a very fortuitous kind of meeting of all minds here in upstate New York. So thank you guys again. So I guess I'll just riff for 10-15 minutes or so, turn over to Professor Jacobson, and then we can kind of have an informal back and forth, and then open up for questions. We're going to do more of a dialogue unless it's kind of a formal Q&A. So the title of this conversation, of this event, is Fighting the Big Tech Menace. So big tech is an issue, unless you've been sleeping under a rock, Rip Van Winkle style, you certainly know that this has been in the news, this percolated all around for a number of years now, it's probably reached somewhat of a climax, honestly, over just the past year or so after Elon Musk acquired Twitter and his revelation, working hand in hand with Barry Weiss and Michael Schellenberger and so forth of the so-called Twitter files. And then there's this very juicy litigation that's currently unfolding right in front of the court that I worked on, the Fifth Circuit, the Missouri versus Biden litigation. And it's a complicated topic because there's a lot of moving parts. But I guess conceptually, if I had to start at kind of a 35,000 foot level view here, just to try to kind of get you guys to visualize the way that I and many others have come to see the fundamental problem, it's somewhat of a paradox, you might say. The fundamental problem is go back to 1776. Go back to 1776 in Philadelphia, and you know you see Thomas Paine running around the town commons with his pamphlet Common Sense, right? I mean, anyone who's been to kind of old Philadelphia, who's been to the Boston Commons, who's been to literally what was called the Commons in England and in colonial America, that was where public speech was aired out. I mean, I studied abroad in London, England for a college semester, and I remember going to Hyde Park, and famously in Hyde Park, they have Speaker's Corner. Unfortunately, I went 2 or 3 times to Speaker's Corner, and then there was no one speaking, but I was told by my grandfather, who was there a half century ago, that back in the day, you would hear people, and you know, my grandfather was a free speech absolutist, he would say you would go there in World War II, where the Nazis are bombing London, you could see someone there, you know, extol the virtues of fascism without legal repercussion. Now, personally, I'm not even sure if I'm that much of a free speech absolutist in an active existential wartime. The point is, though, and what I'm trying to illustrate is that back in the day, whether it was England, colonial America, so forth, you had literal town commons for the airing of public speech. The paradox is that with the rise of the internet, the town commons is happening online. Now, yes, I mean, there is such thing as public parks, where people can go around and they can have discussions, but I would submit to you that if you go to your local public park and you see someone running around with a pamphlet trying to shove it in your face, he is probably more likely to get a citation for loitering or perhaps on some sort of illicit narcotic, as opposed to trying to make some sort of substantive contribution to the public discourse. So we've effectively outsourced, is the point I'm trying to make, this once public good to purportedly private entities. Whether that is Google, whether that is Meta, Facebook, Instagram, Twitter, X, whatever we're calling it now, to a perhaps slightly lesser extent. But those functionally operate, of course, as the modern public square. The problem is that this document, the United States Constitution, fundamentally deals predominantly, not exclusively, but predominantly with state action. Now, there were some things, of course, 14th Amendment slavery. I mean, there are some things where state action is not implicated, but certainly when we're talking about the Bill of Rights here, when we're talking about freedom of speech, freedom of religion, freedom of the press, things like that, we're talking here about state action. So the paradox that we've really had to deal with at both a legal level, a political level, at all these levels, is how to grapple with the fact that we have outsourced this incredibly important public good of the town square of the commons, the airing of discourse, the dialectic, ultimately the pursuit of truth. We've outsourced this to private corporations or public corporations, whether it's the case of an Elon Musk style oligarch or a publicly traded company like Meta or Google, it doesn't particularly matter. And that has led to a whole lot of very thorny problems. It obviously has led to the rise of censorship. It has led to the rise of things slightly more subtle than outright censorship, such as search engine manipulation. So Dr. Robert Epstein is he's a social scientist with some capacity. I can't remember what he got his PhD in, but he testified before the Senate Judiciary Committee in 2017 or 2018, and he testified that Google's, and he's a lifelong Democrat, I should say, he voted for Hillary Clinton in the 2016 election, and he nonetheless testified that based on his own crunching the numbers, Google manipulated the search algorithm so much in the 2016 election so as to hierarchically rank pro-Hillary Clinton articles and hierarchically de-rank pro-Donald Trump articles, so much so that he estimates that Google might have affected the vote up to 3 million total votes across the country. Now, his arguments have been contested by some. I'm not saying to you that that is kind of ironclad tablets from Sinai style truth, but the point is, that is a claim that has been made, and there are others who have supported that. On the other hand, I would submit to you that kind of many kind of common sense kind of empirical observations that all of you can make about the way that social media works. You can see the censorship in real time. I mean, to make a somewhat pedantic, but nonetheless, I think very important point. It simply happens to be true that the sitting president of the United States, after an admittedly terrible event on January 6th, but he was banned from social media. I mean, no matter what you might think about President Trump, and I certainly have my thoughts all across the spectrum from good to bad on him as well, no matter what you think, that should strike us as patently un-American, I would submit to you. There is a long tradition in this country of, unless you are actively inciting a mob-style outrage, a mob-style violence, actively inciting something of that nature, then your speech is fundamentally protected. And over the past few years, as some of these issues have kind of come into light a little more, I think there were certain buckets where the discussion has started to fall down. So one statute that I'm sure most of you are familiar with that started to get a lot of attention would be 47 US Code Section 230, commonly known as Section 230. So Section 230 was passed as part of the Communications Decency Act in 1996. It was a Clinton era statute. It was fundamentally inspired by commitments to tamp down on online pornography and various other lewd and lascivious activities. That was really kind of the modus operandi that's ultimately got litigated to the court. ACLU versus Reno would be the relevant First Amendment case from the late 1990s there. But this was really kind of, and you have to remember, this was back in the very early days of the internet. When Section 230 was passed, I think the number of total US households with internet was roughly 30 million. It was that old, I mean, you guys are probably too young to remember this, but it was that old AOL dial-up modem, which I barely remember, so you guys definitely don't remember it there. But the internet was a fundamentally different place. And the claims that Congress made, or what they were trying to do in Section 230, was they were trying to say that what the statute referred to as an ICS, or an interactive computer service, which they define in XYZ way. If you are an interactive computer service, aka a social media platform or just a platform in general, then you will not be treated as a publisher for purposes of defamation or for purposes of liability. The problem, again, that we've seen over the past few years in particular is that so-called interactive computer services under the statute are acting exactly like publishers. And increasingly, they're not even hiding it. I mean, again, I'm not gonna do kind of a dry recitation of the Twitter files, but you can very clearly see how, for example, in the aftermath of the New York Post Hunter Biden laptop story, how the FBI, working in close contact with Jack Dorsey and the various other head honchos of Twitter at that time, they were very clearly making editorial decisions that had the effect of chilling and suppressing free online speech that would be First Amendment protected if it were said in a physical governmental comment. I mean, the New York Post, for God's sake, which is the nation's, I think, oldest continually operating daily newspaper, founded by Alexander Hamilton himself, was literally locked out of its own Twitter account for 2.5 weeks on the precipice of a presidential election for reporting on a story that 51 spooks said at the time was Russian disinformation, and have since kind of sort of apologized for getting it wrong, but not really fully acknowledged that they got it totally wrong. Still waiting for some accountability for that. But the relevant point for Section 230 that I would make, and here I will be a little pedantic and actually read the statute here. So the way that I read Section 230 is subsection A of the statute is Congress enumerates findings. Now, this is where I kind of connect this particular topic to my work on the jurisprudential front, where I have a whole theory called common good originalism. I'm not going to get into that, but it basically amounts to kind of an attempt to re-imbue constitutional interpretation with some sense of moralistic purposivism, what Aristotle would call a telos, basically trying to kind of urge us not to forget what this whole thing was about in the first place, to try to kind of interpret the specific words in the context of the higher overarching purposes. So I would note here, the one thing that Congress explicitly finds in subsection A of Section 230 is they say, quote, the internet and other interactive computer services offer a forum for a true diversity of political discourse. They're aiming for a true diversity of political discourse here. And the implicit quid pro quo that I read when I read this statute is that in exchange for the true diversity of political discourse, Then you get the liability protection in subsection C of the statute where it says no provider or user of an interactive computer service shall be treated as the publisher for purposes of defamation or liability. And then here's the key part as well. This is the so-called Good Samaritan provision that is really kind of the crux of the Section 230 debate. So it reads, quote, no provider or user of an interactive computer service shall be held liable on account of any action voluntarily taken in good faith to restrict access to or availability of material that the provider or user considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected. So that lattermost part, I would argue to you, is facially unconstitutional because Congress cannot immunize private conduct that would be unconstitutional if it were speech on a sidewalk or a commons. There is direct Supreme Court precedent on this. The 1973 case called Norwood versus Harrison actually explicitly said that it is, quote, axiomatic, meaning it is self-evident that Congress cannot immunize purportedly private actors to do that which the government itself cannot do. So that otherwise objectionable, or sorry, that whether or not such material is constitutionally protected language, I would argue, is facially unconstitutional. Now, the otherwise objectionable catch-all provision, this is how social media, this is the loophole where they operate. Most federal and state courts, up until the past few years, this is where they basically give the big tech companies carte blanche to do whatever they want when it comes to that joke. Oh, it's otherwise objectionable, editorial discretion, you guys get away with it. But any reasonable reading of that list of grievances that I just read would suggest that this otherwise objectionable catch-all is not this sweeping term that I think the big tech apologists, the Google ops and so forth, make it out to be. Rather, I think, as professors Adam Candy of Michigan State and Eugene Volokh of UCLA have argued, and they cite here a venerable statutory canon of construction known as, I'm going to butcher the Latin, but it's referred to as a justum generis, which basically means when you have a general term at the end of a list of specific terms, the general term can naturally only be read within the confines of the other specific term. So this idea here that otherwise objectionable can lead you to censor kind of religious or political speech or something like that, I think is utterly ludicrous. For me personally, my own proposal for how to fix Section 230, in addition to, I think, just holding unconstitutional the facially unconstitutional provision, would be what I would do is I would have Congress legislate and explicitly tie this extra legal immunity provision where they are not treated as a publisher. I would say that you only receive that provision in exchange for having a First Amendment standard on your platform, whereby you are not making censorship editorial decisions to suppress, derank, and so forth speech that would be First Amendment protected if we're said on a public sidewalk. I think Senator Rubio of Florida had legislation along those lines 2 years ago. That strikes me as common sense. There's other major buckets of discussion in this category as well. There's been a whole resurgence of kind of interest in antitrust. You see this very kind of interesting, kind of more populist realignment play out in many ways before our eyes here. You see folks like Josh Hawley, the very conservative senator from Missouri, who nonetheless supports the very progressive Lena Khan, the FTC chair, who has played a little fast and loose with her authority in some ways. But this really is ultimately, in many ways, I would argue, is not a particularly partisan issue. So, for example, the current lawsuit by the states against Google, it's an antitrust lawsuit against Google. It's either 49 or literally all 50 states are joined in that current lawsuit against Google for being a natural monopolist. I personally think that the argument for at least Google and Amazon being, say, natural monopoly under the plain definition of the Sherman and Clayton Antitrust Acts would be very strong here. And the final bucket discussion, which I think gets under discussed, is probably my most passionate one actually, would be common carriage doctrine. So this is kind of an ancient kind of English common law doctrine. Sir Matthew Hale, back in the 1500s, 1600s, whenever he lived, he basically summarized and said that there are some purportedly private functions that are so, and the language he uses, they're so clothed in the public interest, such that even though they are privately chartered corporations carrying out these activities, they have to be regulated in a certain way. And that certain way amounts to something of a quid pro quo, whereby these private companies gets some sort of extra legal immunity, typically tort immunity. So an example here would be the railroads, which are common carriers, they are immune from various tort claims. And in exchange for that extra legal immunity, you cannot discriminate. It's a non-discrimination provision. The key argument there, which Professor Phil Hamburger has made, who's also been leading the charge in the Missouri versus Biden litigation, the key point that he has made is that Section 230 kind of already actually is the carrot. There's just been no stick. And this stick could happen one of two ways. It could happen by a direct regulation under Title II of the Communications Act, a New Deal era statute. It could also come by a direct congressional legislation. Senator Hagerty of Tennessee proposed like a statute along those lines in 2021, I believe it was. I personally ultimately think common carriage is the path forward. I see no particularly good reason personally as to why internet service providers, ISPs, should be treated as common carriers, but companies with frankly much more importance than those companies are not treated as common carriers, companies like Google and Meta. So that's kind of where I've been making my arguments over the past couple of years. The final thing that I guess I'll end on for this introductory pitch is what I just briefly mentioned, which is Missouri versus Biden, which is this really fascinating litigation that's again, it's literally playing out in real time. So I've been following this since the get-go. So it was May 2022 when then Attorney General, now US Senator from Missouri, Eric Schmidt, along with his Louisiana counterpart, Jeff Landry, they filed what at the time would have struck many as a bit of a Hail Mary claim. They basically alleged that the federal government, namely the Biden administration, was working hand in glove with the big tech companies trying to suppress online speech, particularly pertaining to the COVID-19 pandemic and also the 2020 election, but really above all, the COVID-19 pandemic, mask mandates, vaccine efficacy, things of that nature there. And it was August of 2022, so just over a year ago, when we kind of first saw what the discovery of that litigation had yielded, and it was pretty crazy stuff. I mean, we saw like the public documentation of how pretty high-ranking people in the Biden White House were having weekly, bi-weekly, monthly calls with C-suite level people from Meta, Facebook, Twitter, effectively just saying like, you know, these accounts are a problem, like, can you please do something about it? And really not being particularly subtle about it, frankly, in .gov, you know, government emails, which is not a very smart thing to do, as anyone familiar with FOIA, I think, could probably tell you. Long story short, on July 4th, a very fitting date, July 4th, earlier this summer, Judge Doty in the Western District of Louisiana had a sweeping, like 154-page ruling or something like that, where he put a preliminary injunction on many agencies, HHS, Department of State, the FBI, the White House itself, I think, from directly communicating with these tech companies. I'm not going to read the opinion to you, you can read it for yourself. It's really eye-opening stuff. The evidence I find to be pretty overwhelming. He describes it as arguably the greatest attack on free speech in the history of the United States. He describes it as Orwellian. Most recently, just I think less than 2 weeks ago, the Fifth Circuit in a per hearing opinion largely upheld Judge Doty's preliminary injunction. They narrowed the PI slightly. They applied it to fewer agencies. So for example, CISA, the Cyber Security and Infrastructure Security Agency, which is in many ways kind of the center point, the focal point of this entire kind of censorship industrial complex. In many ways, they're kind of ground zero. Unfortunately, the Fifth Circuit narrowed the injunction so as to exclude them. Ultimately, this thing is clearly headed to the Supreme Court. It'll probably go before the Fifth Circuit en banc before then. It's really fascinating stuff. But again, I'll just end on this note. The fascinating thing here is you are really seeing the federal courts grapple in real time with the conceptual problem that I described at the very beginning, which is this is a public function that we have outsourced to purportedly private entities. And we're seeing how to grapple with the US Constitution, how it applies to that in real time. The free speech clause textual hook, you know, the free speech clause here is Congress shall make no law abridging the freedom of speech. The key word there is abridging. Abridging is kind of a broad word, right? I mean, if a government actor is is taking an action with the effect of suppressing First Amendment protected speech, it probably falls under that. So I look forward to seeing what happens in Missouri versus Biden. I would encourage all of you to follow it as well. And I'm not sure if then.
Well, thank you for that presentation. Thank you to the Federalist Society for inviting me to be here tonight. I'll offer kind of a personal perspective on choke point that it becomes social media. So the irony of social media is that it was supposed to broaden the conversation, it's supposed to broaden your ability to express yourself and to reach out to people. But because of the consolidation of power within a few companies that and a few platforms, and the ability of the government to put pressure on those platforms, we're really in, I think, a very dangerous situation. I don't know what the answer to it is, and Josh has pointed out some of the constitutional, holes there that maybe make it a difficult legal question. But when I started my website, there was a thriving conservative and liberal blogosphere. You might have heard the term blogosphere. You would start your own platform, people would interact with each other. Very few people were on Facebook. This would be 2008. Twitter, I think they existed, but nothing like they are now. And that community over time got destroyed by social media, because you could start a blog, you could put a lot of time into it. Maybe you'd get a few hundred people to visit, maybe you wouldn't, maybe people would share your stuff. But over time, particularly Twitter destroyed both left and right blogospheres, because it's so much easier just to open a Twitter account. It's free, it used to be free. You could reach tens of thousands of people, and if you were outrageous enough, you could get tens of thousands of followers, and it was a whole lot less work. So over time, what you had is you had this independent blogosphere, left and right, which got destroyed by Twitter, I'd say more than Facebook, or Facebook to some extent. And then, so what you have this migration of political conversation to a couple of platforms, and I would say Facebook and Twitter are the two platforms. I'd say Twitter probably more, but they're completely dominant. Now there are other platforms, but Facebook has bought Instagram, and there's a consolidation. So what you have is people on mostly a couple of platforms, and we've witnessed what's happened over the years. Put aside government pressure, which is a throttling, from my perspective, of right of center platforms. We built up over time in the early years of Facebook over 300,000 followers, and those were real followers. It wasn't purchased followers or bots or anything like that. And over time, Facebook was a big part of our blog traffic. Not huge, not like some websites, but it was 10, 15% right there. And we get our post something on the blog, post it on Facebook, get several hundred shares on Facebook, tens of thousands of views, etc. And over time, we started getting throttled. And you don't see it in real time, you see it in the analytics of it. Nothing changed for us. And we're at the point now where we have over 300,000 followers, and we're lucky if Facebook shows our content to 300 or 400 people on Facebook. So we're totally throttled there. Twitter we've never been big on Twitter, but Facebook, we've also started to notice the flagging of our posts. And that became more prominent in the last 3, 4, 5 years. And if you get 2 or 3, I think it's 3 flags, they tell you they're going to throttle you. So in addition to actually throttling you, they tell you, they put your page on restriction under threat of being deplatformed. And what are the sort of things we get throttled on? At least us, it was really 2 things. It was COVID and it's climate change, global warming. So we published a post reporting, really literally just quoting newspaper reports from Australia when they had some horrible fires a couple of years ago, and how they were started by arsonists. I mean, that was well documented in Australia that they were started by arsonists, these fires. So we literally published a post, arson, the cause of the fires in Australia. We cite 3 or 4 or 5. We get flagged on that post. one of their fact checkers flagged us. And the only time we've ever been flagged, the explanation, we've never been flagged for publishing false material. It's lack of context. So the lack of context is when we wrote that the fires were started by arsonists, as reported in Australia. We didn't add to it, and the fires were made worse by global warming. So Facebook dings our post, shields it from people, and counts it as a strike against our page. And we've seen that more and more and more. So Facebook and Twitter and other platforms have got, before the government got involved, were very used to exerting their power and throttling people and stifling people. And then you have the government get involved, and that's mostly, I think, or at least we know of, COVID related. And I think the things that have been revealed in the Twitter files, but also this litigation we've been following are pretty startling, where the government really didn't mince words about cracking down and throttling people and deplatforming them. So we've seen this evolution over time, but it becomes more dangerous when the government gets involved, because government has all this power. Government can give Meta, or whatever they're called now, serious regulatory hassles at 30 different levels if they don't cooperate. The government can create problems for people. And so we're in this situation where we have a consolidation of political speech in a handful of platforms. Those platforms have a natural inclination to stifle right of center voices. And now we have government pressure on them as well. So I think it's extremely important. I think we're in a very dangerous situation. I don't know what the way out is, but I think people need to be aware of what's happening. So that's my perspective on that.
Yeah, I mean, I think it's worth emphasizing something that, and thank you, that Professor Jacobson just underscored, which is, I did kind of fast forward a little bit to kind of, you know, I basically fast forwarded over the problem. I very quickly addressed the problem. And yeah, I mean, but before the rise of Missouri versus Biden and our awareness of the government's role, you know, I mean, anyone who is at all anecdotally familiar or who had accounts on Twitter, Facebook, on these platforms, heard all sorts of stories like the one that Professor Jacobson just described here. And they really weren't like trying to hide the ball that much. I mean, like if you look back to, you know, what Jack Dorsey, Mark Zuckerberg, what folks like that were saying, you didn't have to kind of read between the lines that much to see the kind of things that they were trying to prioritize there. But again, the question when we talk about big tech here, I like to frame it sometimes, excuse me, as a question almost of kind of sovereignty, frankly. It's kind of like who watches the watchmen? I mean, who makes the rules for the discourse? Are we going to outsource the rules for the contestation of ideas, for the duking it out of ideas? Are we going to kind of outsource this to the mercurial and ever-changing vicissitudes of kind of a cabal of Stanford and Cal Berkeley PhDs out in Silicon Valley? Or are we going to try to take some semblance of kind of we the people style control over our own destiny and ultimately exert some sort of lowercase r Republican self-governance over this? And you know, in many ways, kind of this rejuvenated kind of sense of trying to control out of control corporate tyranny that you've seen in recent years, it's kind of just a rediscovery of an older tradition. I mean, back in the day, this would have been readily recognized as the Hamiltonian tradition of American political economy. Teddy Roosevelt, obviously, is a very straightforward analogy. You know, in many ways, kind of the Republican Party's kind of renewed interest in antitrust for the past few years, kind of just returned to home, actually. I mean, so the Sherman Act, the original antitrust statute itself was named after Congressman Sherman from Ohio, who was literally the brother of William Tecumseh Sherman, the general for Abraham Lincoln. This is an illustrious Republican family, and I'm not gonna make this partisan, obviously, but in many ways, it's kind of a return to home here. And look, I mean, I don't claim to know what all of the answers are either. I tend to say my general approach is that there's no one size fits all remedy. I mean, you're talking about different platforms here that serve different functions. So Amazon, I've argued in very forthright fashion. I had a long essay on this 2 years ago for American Affairs Journal. I think that Amazon, under a very standard antitrust analysis, is a monopolist that should be broken up. Ditto Google. I think Google, frankly, probably will be held to be a monopolist. So there was litigation that just got underway from the federal government. So there's multiple antitrust suits against Google right now. There's the state's lawsuit. I think Ken Paxton started that, but it's literally 49 50 states. It's a very bipartisan endeavor. And there's also a federal antitrust lawsuit against Google right now. It was just, it was literally last week, I think it was last Monday in Washington, D.C. that started to get underway. The Biden administration actually picked that up from the Trump administration. The Trump administration under Attorney General Bill Barr was one that had commenced that antitrust suit against Google in its final year, I think, or two, but I think the final year of that administration, the Biden administration, to its credit, decided to kind of keep that intact, and they are now carrying through. So Google is like a quintessentially bipartisan issue right now. I think basically everyone should be Google skeptical or outright anti-Google unless you're a paid shill by Google, and I have debated those types personally. I'm not gonna name names here, Carl Sapo, but that's okay. If you got no next choice, you know what I'm talking about. But again, I would encourage all of you to pay attention to the way that the Missouri versus Biden litigation unfolds here, because when it comes to the government's role specifically here, that is when it starts to get just profoundly dangerous. I mean, if you, for those of you who have not read Judge Doty's preliminary injunction in Missouri versus Biden, you really ought to do so. I mean, judges don't typically just lay it out on the line like this, and like in 160 pages, kind of literally just saying like this is Orwellian stuff. I mean, all the speech happens to be from one side of the political aisle here. It's really eye-opening, and fundamentally, I mean, if we care about the First Amendment, then we are forced to care about these issues. Like I said, ultimately for a lot of these platforms like Facebook, Meta, and so forth, I do come down on the side of common carriage regulation, because it just strikes me that they fundamentally serve that role. They serve a public function that should be regulated under common carriage doctrine, but unfortunately the public discourse is not currently there, but I guess we'll see where it goes.
Yeah, there's a lot of talk about, reforming Section 230 and so on. It does provide, I think if there's any reform, it's got to be clear that that applies to the large platforms. The smaller platforms, I mean, we would just simply shut down the comment section if we didn't have some sort of legal protection. I think every website, like a lot have shut it down, have shut down anyway for other reasons. Because comment sections get out of control. But I think we just have to make sure that whatever the remedy is, it's not worse than the disease that we're purporting to cure. So yeah, I think I did read, I can't say I've committed it to memory, and there were some sections I skipped over, the 160, 70, 80, I don't remember how many pages it was.
It was a lot.
It was long. I mean, it's all there, it's laid out. And the Fifth Circuit decision did scale back the injunctive relief, and I thought they would when I saw the trial court judge's injunction. It's a hard thing. How do you tell the government you can't speak to people? And at what point does speaking to them turn into coercion or pressure? It's a very hard line to draw. And I think that the Fifth Circuit cut that back significantly, but, and that's where I think it will be a problem. The government's view is, well, we have free speech rights too. We get to speak our mind. And, I think both courts said, well, yes, but you don't get to tell other entities to stop citizens from speaking as the government. So it'll be very interesting what happens, but I think it's certainly, would be very helpful if that decision does hold up.
Yeah, and I guess the final thing I'll say, and then we can open up to questions from you guys. I think I'm not sure exactly what we're trying to turn over, but I'm just ballparking here. But I guess the final thing I'll say is the thing that has really interested me over the past few years, and probably the reason that I started following the big tech debates in the first place, and it's a point that I've made over and over again already in our brief 30 minutes here, or whatever, is that this notion of a clean distinction between the public and the private. I mean, that distinction really kind of underlines all of classical liberal theory. I mean, classical liberalism is kind of predicated upon this kind of sharp distinction between the public and the private. The public domain is this, John Stuart Mill, the Harm Principle, all that stuff, right? But what do you do when the line between the public and the private starts to really get blurry and murky? I mean, these are thorny questions, not just legally and not just constitutionally, but frankly, philosophically as well. I mean, no one wants to live, or at least most people I think in this room probably do not want to live in a society where the public sector, has just free reign over the private sector. Perhaps we just try to nationalize everything and just try to kind of get rid of private ownership. I mean, that hasn't exactly worked out well for societies that have gone down that road in the past there. On the other hand, clearly, some level of trying to keep the government in line is appropriate as we're seeing time and time again. So, like I said, I don't currently have all of the answers here necessarily as well. I do know that there is a huge problem. One solution that I do not think is the solution is the so-called benevolent oligarch solution. Which is basically the argument that I hear from some where we just need kind of like 20 Elon Musks. This is not a solution. And anyone who I think thinks that this is a solution, I think should be disabused of that notion. Personally, I actually think that as a somewhat frequent inhabitant of the Twitter sphere to the detriment of my mental health, but I think that Twitter is honestly actually worse under Elon Musk than it was prior for numerous reasons that are probably not fully worth getting into. Yes, fewer accounts are banned, which is nice. I think that there are many downsides to the current variant of Twitter as well. More generally speaking, we don't want to rely on that. I mean, it's common sense that we shouldn't be reliant upon people worth whatever he's worth, $200 to $300 billion, whatever. We shouldn't be reliant on that for the maintenance of a free online domain. I mean, that's absolutely crazy to me. So. Maybe it's good, maybe it's bad that Elon Musk decided to take over Twitter. I agree that it's great that a lot of accounts that were banned are now back operating the platform. It's come at a cost. Elon is a very unpredictable man himself. He has very close ties with the Chinese Communist Party, among other glaring red flags. I would just say that is not a solution. That the solution has to be a fundamentally political solution, kind of in that direct kind of American vein of Hamilton, Teddy Roosevelt, kind of orienting your political economy towards reining in corporate tyranny, especially when kind of outsized corporate power is affecting such a crucially quasi-constitutional domain, and especially when that quasi-constitutional domain is then tilted against one side very clearly of the political eye. So maybe we want to open up to questions.
Why do you think it is that it seems like the vast majority of these companies do lean left, and there is no response from people on the right creating their own platforms? I know there is Rumble and other things like that, but why are the vast majority of these information companies, I would say, including digital news and all of that, why does it lean left? Do you think it is the background of these people? Do you think it's a corporate ESG type of thing? Do you think it's government, something to please, the governing bodies?
Yeah, I think it's a good question. I mean, I'm not sure, obviously, I can just guess. I mean, my best guess is that it probably is a cultural thing. I mean, back in the day, tech was not a partisan issue. I mean, Section 230 passed by overwhelming margin. In fact, in the 1990s, when Section 230 was flying through Congress, it wasn't just the Clinton Democrats that were wooing big tech, it was also the Newt Gingrich Republicans. I mean, everyone wanted big tech. At the time, Silicon Valley was seen as the great American industry, right? I mean, go West, young man. And then I mean, that was the great era of the .com companies and all of that. But yeah, over the next kind of 10, 15 years, as we kind of saw the rise of a monolithic and hegemonic progressivism in kind of various institutions in the academy. I mean, California, obviously, since the Reagan era, has tended to lean left. The San Francisco Bay Area, which breeds a ton of these companies, disproportionately leans very left. I mean, it's the home of Pelosi, Van Feinstein, all these illustrious Democratic royalty families and so forth there. So, you can't ignore that, right? I mean, institutions like Stanford and Cal Berkeley, which disproportionately do breed a lot of the computer scientists and the engineers here, they kind of grow up in that milieu. They are exposed to that kind of social environment. They are probably taught. So that's my best working thesis. I can't tell you that like I've closely studied whether like the ratio of like DEI officers per company is higher in that industry versus, take any other industry, I just don't know, so that's my best guess. And then at some point it becomes kind of a self-fulfilling prophecy, right? I mean, at some point when the companies start to act that way, Republicans recoil, and then when they recoil, then the companies kind of double down, so it becomes kind of a self-fulfilling whirlpool. I'm not sure if you.
Yeah, I mean, I think it's a cultural thing. I think that, for whatever the reason, media journalism tends to attract people more from the left than from the right, and then it gets consolidated. I think the fact that Silicon Valley was in Silicon Valley, California, in a generally liberal environment probably contributed to it. So I think it's like many things, that it's more a cultural phenomenon, and politics was, many people have said, downstream from culture. So I don't think there's any, grand design to make it that way. I think it's just a cultural thing. Same with the entertainment industry.
Josiah?
So, thank you for being here, Mr. Heyman. You mentioned, in your argument for why that portion of Section 30 is basically unconstitutional, the principle the Supreme Court has laid down that Congress can't immunize private actors for things it can't do. And I want to borrow your phrase, suggest that anyone who believes that needs to be disabused of that. I'm a religious person, so I say lots of things that if the government said them would violate the Constitution. Do you really think that the government immunizing me from state law liability for saying those things violates the Constitution?
Sorry, I'm not sure I fully understand this, but can you give a hypothetical, or maybe like a specific?
So if a state law, maybe a public accommodations law, to take a timely topic, imposed liability on me for making religious statements, would it really be unconstitutional, as your argument seems to suggest, for Congress to immunize me from making that statement from state law liability? So that's exactly what 230 does, is immunize private actors for their own constitutional commitments.
Well, the state law you're suggesting would be unconstitutional, would it not? I mean, you're saying a state law would somehow find you liable for professing your faith publicly?
For instance, CLS versus Martinez, we could have upheld. But there are many ways that the state could do that would be constitutional. For instance, if it were content neutral.
Look, I'll be honest, I did not read CLS versus Martinez since I was in law school, so I do not remember the exact fact pattern in that case there. I mean, I don't understand how a state law criminalizing or illegalizing the profession of one's religion could possibly be upheld in a court of law. That just doesn't make any sense to me. I mean, how is that not a?
Say the courts get it wrong and Congress wants to overrule them. Your argument would make it unconstitutional for Congress to overrule them. Because it's immunizing me for my private action in the same way 30 does. It
So-
seems to me like the Supreme Court spoke too broadly in the language you quoted. I'm trying to figure out whether you really think it's as broad as they say it is.
I'm still trying to get my head around the exact hypothetical that you laid out here. Look, I mean, if a state were to pass a law that would somehow say that it is illegal, it is criminal conduct, God forbid, for you to go out in the public square and profess your faith in Jesus Christ or whoever your Lord is there, that statute would be facially unconstitutional, obviously, and struck down by any court. And I mean, if not, then you have a tyrannical situation there, obviously. I mean, so we're dealing with like a bizarre abstract hypothetical here. I mean, again, I would have to reread CLS versus Martinez to reply myself the exact fact pattern there. Certainly for Congress to kind of step in and make kind of a RFRA style legislation to overrule a state court, and I'd have to like think through the mechanics of how that would work under Section 5 of the amendment, but certainly that would strike me as a very straightforward legal recourse. And if that is in loggerheads with the broad principle announced in the Norwood versus Harrington case, then maybe that broad principle should be rethought, but we're dealing here with like a series of hypotheticals. Something.
Yes, thank you both for being here. I just had a question about the tech companies, as I understand it, tech companies' argument is that they're responding to advertiser pressure in censoring certain views because advertisers are unfriendly to whether that's ESG pressure or whatever, advertisers are more friendly to certain topics than they are to other topics, especially COVID or climate change or things like that. And that the reason that they're taking these actions is economic, and then basically by introducing true free speech to their platforms, they're going to lose all a bunch of money. What's your response to that argument, or do you think it just doesn't matter? They just have to take the hit.
Well, again, if they're not being pressured by the government to do things, I think they're entitled to run their business. Whether that's a good thing or not is a different question. We do understand that a lot of the advertiser pressure is highly organized. It's not organic at all. There are groups like Media Matters and others whose entire business model is to pressure advertisers to not advertise on Fox News and elsewhere, and to try to demonetize conservative figures. So I don't believe that there's an organic advertiser movement not to advertise to Republicans or to conservatives, to half the country.
Right.
Roughly, I do believe there is a highly organized movement, which has become even more organized in the last few years, to pressure advertisers. So if Facebook is saying that's why they're doing what they're doing, understand that that's under pressure. That's not purely a business model. I'm not sure what you can do about it, but I don't believe for a second that there's an organic corporate urge not to reach half the country.
Yeah, I tend to agree with that, and you finally started to see, I would note, really just over the past 5-6 months, corporate America starting to realize that when the right half of the country starts to kind of pool its resources, that it can actually do damage, take scalps, or really make change in general. I mean, we saw what happened with Dylan Mulvaney and Bud Light. We saw what happened with Target, and the stocks these companies have taken a tremendous hit. I mean, even just culturally speaking, for a long time, kind of for like the music fans out there, for a long time, kind of the top 100, like a hot 100 music rankings tended to kind of keep away country music. So I'm a big country music fan. And they did this for reasons that people speculate possibly had to do with the fact that country music disproportionately appeals to kind of blue collar, middle America, right, people and so forth. And finally this summer we've seen multiple culturally kind of third rail country songs reach the very top of the charts, whether it's Jason Aldean's song "Try That in a Small Town" or Oliver Anthony's song "Rich Men North of Richmond." So we finally started to see a bit of a corporate backlash there. I mean, as some people say, when you go woke, you go broke. I'm not really sure if that's exactly right, but we're starting to see at least some instances of it. I still do not think that Anheuser-Busch has recovered anywhere close to their stock. Certainly the Walt Disney Company took a tremendous hit last year from its stock price as well during the course of its still ongoing battles with Governor DeSantis in my state of Florida. And yeah, a lot of this is definitely kind of quasi astroturf, to use a very online term. A lot of this kind of sentiment comes from, I mean, we've seen this in just the past 2 weeks with the whole Elon Musk versus ABL fight, right? The ABL is not the only actor. I mean, yes, they'll see a lot of these folks, but tremendous pressure on advertisers. I mean, some people speculate that one of the reasons perhaps that Tucker Carlson was ultimately fired from Fox is that just the advertisers just got such tremendous pressure. Now we don't know why he was fired. Obviously, they had the massive settlement with Dominion. I'm not saying that was the reason, or maybe even like one of the bigger reasons, but some people at least speculate that, right? But I mean, fundamentally, what Professor Jacobson said is right. Is that, I mean, this is half the country. I mean, a political opinion polling in America reliably shows the country is basically close to 50-50 split on any number of issues here, and it just doesn't make sense from an economic perspective, especially for a company. I mean, let's say Google or Meta. I mean, Google's market share when it comes to online search is over 90%. I mean, hold aside like their monopolistic status, they're serving everyone. I mean, they are very clearly serving people with all sorts of political ideologies. The percentage of United States American adults who report having a Facebook account, last time I checked, was like 77 to 78%. So it's the same situation there. It just does not make sense to kind of do this unless there's some sort of astroturfing campaign.
We just have time for two more questions. Louis?
Thank you guys both for being here for this big, thank you, talking as well as Mr. Hammer. Also, you came at the right time for everything, so, you know, I hope you enjoyed it here. What I was gonna say, so in terms of how much like these tech companies like should like monitor the stuff that they put out, like in the Gonzalez for School case, you see that like they can't monitor everything that's put on their platforms, and I was just wondering what y'all's thoughts were on like how much like do they need to be held, you know, in check by the government, or how much does like section 230 apply to like the stuff that's being put out that they don't have the opportunity to check it and all that?
Yeah, it's a real question, right? And it's a good question, and this is a concern that many raised with section 230. So this is actually why I do not come down on the side of just getting rid of section 230. So there were some people who, after kind of the rise of the censorship industrial complex over the past 3-4 years, they kind of conclude just get rid of section 230, and I don't actually agree with that. I like I said earlier, what my remedy would be to statutorily tie the extra legal immunity provision to a First Amendment standard. Meaning that if you fail to abide by the First Amendment, then you will lose your extra legal immunity. But I'm not actually trying to get rid of that extra legal immunity. So I'm actually okay with the tech platforms being treated not as publishers, even though they, you know, might act like public because they would have then a First Amendment. Gonzalez versus Google is an interesting case. Look, it obviously is absurd to expect Google, YouTube, for instance, to pore over with a fine-tooth comb, you know, every single video that is uploaded to its website. I mean, no one, I think, would argue that that is what we naturally expect. Again, the First Amendment would entail a lot of like disgusting speech, frankly. It would not permit kind of, you know, calls to violence, calls to incite. So for example, I think, you know, that was I can't remember, was that case or the companion case that involved like the ISIS case out of Paris, right? So I mean, like if someone were to like flag for the relevant authorities that there is like an ISIS recruiter talking about jihad on YouTube, then Google should take it down because that is not protected by the First Amendment. But I wouldn't necessarily expect, you know, Google to kind of affirmatively do that if this video has like one view before anyone. I'm not sure if that answers the question, but I mean, but I have no expectation that they would literally monitor every single post from someone who has 0 followers and like 1 view or whatever.
All right, last question.
I would love to hear both of your thoughts on generative AI, like ChatGPT, specifically like with the rate of technological change that it exemplifies. Do you think there's any hope for like broad or oversweeping legislation that could account for the type of change that we're seeing?
AI, frankly, is an issue that I have not fully developed my thoughts on yet. It's kind of playing out before our own eyes. I do know that it terrifies me greatly. It terrifies me greatly. One, as someone whose career is built at least partially around like writing. I mean, like, what is my profession going to go extinct, basically? No, seriously, I mean, it's kind of funny, right? I mean, I've written like so many words and columns, op-eds, essays, articles, all this stuff. I mean, sometimes I have a thought, I've never done this, and I'm not going to because I'm an ethical person, or at least I would try to be, but like, I have this thought, like, should I like ChatGPT my next column? I mean, like, I don't even know what, I don't know like, what that, I've never been to the website, and I don't even know like what this would look like in practice, but it does terrify me for pure kind of vocational kind of career reasons, frankly. But the ethical quandaries are sprawling and manifold, right? And I say this as someone who, in many ways, is kind of not super bullish on technology in general, not to sound like a crotchety old guy, but not all technology is necessarily a good thing. I mean, that's kind of like a sweeping statement, but I don't think it should be particularly controversial. I mean, yes, no one wants to go back to like the Middle Ages, no one wants to go back to like the days before electricity, before the light bulb or anything like that. But, you know, is it really a good thing that, you know, 12-year-old girls are able to watch like TikTok videos that kind of make them lose their mind? I mean, I would argue probably not. If you look at kind of the rates of mental health and depression and tragically even suicide among teenagers, and really, frankly, teenage girls in particular, especially those who spend adamant disproportionate time on Instagram and TikTok, it's deeply, deeply depressing stuff. AI in general greatly worries me for those reasons, for many others. I know at my company, Newsweek, we've kind of begun the discussion about how reporters can start to kind of try to kind of ethically incorporate AI into their work. I'm not a reporter, so I don't have anything to do with that, but I know that the company is having those discussions there. And it'll be fascinating stuff to see. Unfortunately, I'm not sure I have a whole lot more to answer them.
Yeah, I don't understand a lot about the technology behind it. I think I understand a little bit more in terms of how it might be used in medicine, so on, pouring over huge pools of data and finding associations and correlations that might give hints on medical treatments, things like that. From what I've seen, what is generated from AI can be very inaccurate. If it's essentially pulling what's on the internet, why would anybody think that would end up being a good thing? Okay, if that's your source of data is what's on the internet. We all know there's so much garbage on the internet. So I think it's not going to be stopped. It's going to be here. I think people need to figure out how to deal with it. I think universities need to figure out how to deal with it. I'm not sure in favor of banning students using it. I think there should be disclosure if you've used it, honest disclosure. But just like you should cite your source material in your paper, if your source and you're willing to admit you did it, is ChatGPT, then put it there, and whoever's grading that can take that into account. So I don't know where it's going. I don't tend to understand the technology behind it. I thought I understood a little bit about it, and then I ran my understanding by somebody who I think does understand it. He said, "You're all wrong. You got it completely wrong." So, and he gave me some reading material. So, yeah, I don't know where it's going to go, but it's here. It's not going anywhere, and I guess we'll have to see what happens.
Well, thank you both for coming, and thank you all for coming. We will have our next debate on free speech and school choice on this Thursday. Be sure to check your emails. We'll have more information ready for that. So thank you, Jack. Thank you.
Yeah, well, thanks, me, yeah. I'm fine, tonight.
Where you're constantly running into an algorithm. Unconscious, just like,